welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about how to use powers of attorney to avoid costly guardianship proceedings in the case of mental incompetency. So there are two types of powers of attorney. One is a healthcare power of attorney, and the other is a financial power of attorney. And what they do is they name someone to act for you if you're not mentally competent to do so yourself. So the financial power of attorney will name someone to handle your financial and legal matters if you're no longer mentally competent. And you can name successors. So a lot of people will name their spouse and then maybe name friends or children as successor agents if the initial agent that they name isn't able to act for them. And this person can do things like file their tax returns, sell their home, and pay their bills, handle their bank accounts, and act for them in all financial matters. The healthcare power of attorney is the flip side of that coin. It names a guardian of your person who can make major life decisions for you, like where are you going to live, are you going to be checked into assisted living, and it also names someone who can make healthcare decisions for you. This is called your healthcare agent. So if you get into a car accident and the doctor needs to do a risky surgery to try to save your life, your healthcare agent is going to be the person that makes the decision on whether to do that surgery or any other healthcare decisions that need to happen if you're not conscious or mentally competent at the time that the healthcare decision needs to be made. And just like the financial power of attorney, you can name successor agents to act if your initial agent is not able to do so. And the nice thing about a healthcare power of attorney is that it avoids disputes among family members. So we see relatively often a situation where someone is in a situation where they're in an irreversible coma and the family needs to make a decision on whether to terminate life support. And sometimes that can turn into a full-blown dispute with litigation between family members. If you have a healthcare power of attorney, naming someone to make that decision for you, you resolve that dispute. You can also state what your wishes are in the case of an irreversible coma. So you can give your healthcare agent some instruction there. And there's three options. It's a multiple choice. You can either say, I want to be kept alive as long as possible, I want life support terminated in the event of an irreversible coma, or I want my healthcare agent to weigh the benefits and the burdens of continued life support and make the decision themselves. And this isn't legally binding on the healthcare agent, but it gives them some instruction. A living will is something that's used to make a legally binding decision in that arena. So the bottom line is, if you have a financial power of attorney, you've named a financial and legal guardian for yourself. And if you have a healthcare power of attorney, you've named a guardian of your person and someone to make healthcare decisions, and they can be the same person. If you don't have those powers of attorney in place and you become mentally incompetent, then what your loved ones will have to do is file a guardianship proceeding and have someone named as your legal guardian. And they have to do this because you're still going to have to file your tax return, someone's going to need to manage your financial assets, and someone's going to need to make major life decisions for you, like where are you going to be living. And we want to avoid a guardianship proceeding for a couple reasons. One is that it's very expensive. It costs, upwards of $10,000 in attorney's fees and court costs. It also takes about 6 months before someone can be named as your guardian and start acting for you. And if you become mentally incompetent, usually your family members are under enough stress already that they need to be able to act quickly, and going through a lengthy court case to be named your guardian isn't ideal. The third reason guardianship is bad is that it's a real headache for your family members. They have to line up an expert witness to testify as to your mental incompetence and work with an attorney over the course of 6 months to put on a court case. So we really want to avoid it. The real kicker is, though, if they are successful in being named your guardian, your family member is going to have to go into court once a year to file a report as to how they managed your assets. So they basically have to file a report with the court, and the court oversees the guardianship. And that can be costly because that's continuing attorney fees that they have to pay every year, and again, in a court appearance that they have to attend every year. So we can avoid that whole situation. We can avoid a guardianship proceeding by naming ahead of time who your guardian is going to be. And again, that's done through a financial power of attorney and a healthcare power of attorney. And these are really cost effective to do. They're pretty easy for attorneys to prepare. So you don't have to pay a lot to get these done. The kicker is that you need to do them while you're still mentally competent. So if you've already become mentally incompetent, whether it's through old age or disease or an accident, it's too late to do the powers of attorney, and then a guardianship proceeding would be necessary. There's also another flavor of financial power of attorney. So we've talked about the type that kicks in only if you're deemed mentally incompetent. And in order for that to be effective, whoever your agent is would need a certification from your doctor showing that you're mentally incompetent. But there's another type that can be effective immediately. So this is, sometimes for spouses, for ease, they want to be able to sign for each other. You can basically allow your spouse or someone else to be able to undertake financial transactions on your behalf. And this is sometimes seen in the case of an elderly parent who is still mentally competent, but the children are helping to manage their finances. So this allows the financial agent, even though you're still mentally competent, to make financial transactions on your behalf and legal transactions on your behalf. And you can limit that in scope, too, and time. So there's often for, say, a real estate closing, you'll do a financial power of attorney just for a limited time period and just for the purpose of effectuating that real estate closing. So you can limit it for a particular purpose or a particular time period, or you can make it an unlimited purpose and unlimited time period. But as a particular part of an estate plan, we usually do the types of powers of attorney that are effective only upon mental incompetence, and that's because our goal is just to make sure that a guardianship proceeding isn't necessary. So that's really all you need to know about powers of attorney. If you would like to schedule an initial consultation, you can call my office at 630-324-6666. That's 630-324-6666. If you'd like to see more videos, listen to more podcasts, or read more articles on any legal subject, we practice most areas of law, so we have all sorts of different articles. You can go to learn-about-law.com. That's learn-about-law.com, and you can also download us on iTunes. I also have another podcast that I do just for business owners called seizeyourbusiness.com, so please feel free to check that out. Thanks for listening.